It's a story that starts with a question any of us might ask our HOA. Hey, can I see the bills? But what happens when that simple question is met with, well, silence? And then a whole lot of resistance? We're about to get into a case where one homeowner's search for transparency turned into a full-blown legal battle, and it all came down to a judge deciding where the line is between a resident's right to know and an HOA's right to privacy. And this quote, this really gets to the heart of the whole thing, doesn't it? It's from the homeowner, Debbie Westerman, and you can just feel the frustration. She says, all I am looking for are numbers. It seems so basic. So why the big fight? That's the question we're going to dig into. Okay, so this all kicked off with a single email. And on the face of it, it seems like a request any homeowner should be able to make, right? But the specifics of what she was asking for, well, that's where this story really starts. So let's look at the details here. On November 26th, Ms. Westerman sends this email, and she's not just asking for some general budget report. No, she is specifically asking for 10 years' worth of billing statements from a company called Shaw & Lyons, which happens to be the association's own law firm. All she wanted to see was how much her HOA was spending on lawyers. Now, this timeline is absolutely key. In Arizona, the law is pretty clear. An HOA has 10 business days to respond to a request like this. But look at the dates. The first peep she hears from them, which was just an invitation to a meeting, by the way, doesn't come until December 30th. That is way outside the legal window. And that delay, that's what took this from a simple question to an official legal complaint. So at this point, Ms. Westerman feels like she's being totally ignored, and she knows that legal deadline has come and gone. She figures the law is on her side, so she decides, you know what, it's time to stop asking nicely and start making a formal demand. And get this, on December 16th, before she even got that late reply from the HOA, she files a petition. This isn't her typical lawsuit. It's an official administrative hearing, a process set up specifically to see if an HOA has broken state law. The battle lines were officially drawn. So once this case gets in front of a judge, you basically have two completely different stories taking shape. On one side, you've got a homeowner who just wants to see the numbers, and on the other, you have an organization saying, hold on, we have to protect our legal integrity. It's a classic fight between transparency and procedure. And this lays out the conflict perfectly. Ms. Westerman's case is super simple. I asked for numbers, and you guys missed the legal deadline. Easy. But the HOA's defense? It was way more technical. They claimed her request wasn't even made properly, and, this is the big one, that the documents she wanted, those legal bills, were exempt from disclosure because they were legally privileged conversations with their lawyer. And that defense, this idea that some records are just off limits, that's where this whole thing really comes to a head. The entire case was going to come down to not emails, not timelines, but the very specific wording of a single state law. So you look at the law, and at first glance, you think, okay, this is a slam dunk for the homeowner. It says right there, black and white, 10 business days. Period. You'd think, based on this sentence alone, it's an open and shut case. But you know it's never that simple, right? And there it is, the two little words that change everything, except as. This tiny phrase is basically a legal escape hatch. It points to a whole list of exceptions where that 10-day rule, and maybe even the right to see records at all, just might not apply. So what's in this mysterious subsection B? Boom. This is the exact exception the HOA built their entire case on. The law says flat out that an association can withhold records if they are part of a privileged communication with its lawyer. The HOA argued that their legal bills, which detail all the work their attorneys did for them, fall squarely into that protected category. So you've got these two competing views of the law. How did the judge rule? Did the homeowner's right to transparency win out, or did the HOA's claim of privilege hold up? Let's break down the final verdict. Well, in the end, the judge actually sided with the HOA. After looking at all the arguments, the judge decided that, yes, those legal bills were, in fact, privileged documents. And that one finding was the domino that knocked over the entire case. And once that happened, everything else just kind of fell into place. See, because the documents were privileged, the judge ruled that the 10-day deadline from the first part of the law just didn't apply to them. That meant Ms. Westerman couldn't actually prove the HOA broke the law. Her petition was denied, and the HOA walked away the winner. So what's the big lesson here for the rest of us? I think it's that a homeowner's right to see the books isn't unlimited. It's not absolute. While transparency is supposed to be the rule, this powerful legal idea of attorney-client privilege can act like a shield, and it can keep some really sensitive documents, like legal bills, under wraps. And that kind of leaves us with this big, lingering question. This case really shines a light on a tension that exists in pretty much any HOA. We all want transparency, right? But at the same time, organizations need a certain amount of privacy to function, especially when they're dealing with legal stuff. So where do you draw that line? It's definitely something to think about.